No, we're ready.
Okay. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner. I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings moving forward, you have the following rights: to the presumption of innocence, to indictment by grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf, or offer evidence in your own defense, and to have an attorney appointed to represent you. And to have an attorney represent you. But if you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. Ms. Toles, I see you are on. I'm going to come to you in a second. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized to set, authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be considered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Finally, I need everyone to raise your right hand, please. Do you swear affirm that any statements that you make during this proceeding will be the truth, the whole truth, so help you God? Okay, so Ms. Toles has logged on. So we're going to modify what we're going to do. Ms. Toles, there are 2 individuals on the male side and 1 on the female side. So let's deal with the 2 individuals on the male side first. The person on the female side is Ms. Castellanos. Her warrant number is 2021 WA 16228.
I have it, Your Honor. Thank you.
Okay. Could you tell me, deputies, who is the person on the male side that, who are the 2 individuals on the male side that we're going to address?
Garcia Saul and Galgos Manuel.
Okay. All right, give me a second. So I have a Manuel Gallegos. Is that the person?
Yes.
And Saul Garcia.
Yes, sir, that's correct.
So those are the 2.
Yes.
Do you have that information, Ms. Tolles, for those
I do,
2
Your
individuals?
Honor. Thank
Okay.
you.
Okay, so let's bring up Mr. Gallegos first.
Manuel, ven aquí. This is
Mr. Gallegos, sir, can you hear and understand the interpreter?
Hola, buenos días, señor Gallegos. ¿Puede usted oír y entender al intérprete?
Sir, you're charged
Yes.
with 1 offense of driving a vehicle with an expired license.
Señor, se le está acusando de una infracción de manejar un vehículo con la licencia suspendida. If the interpreter may interrupt, Your Honor, the interpreter may have gotten confused. Expired or suspended?
It says expired.
I need to make a correction then. Buenos días, señor. Se le acusa de una infracción de manejar con la licencia vencida. Okay.
This is your first appearance here.
Esta aquí es su comparecencia inicial.
Everyone. Morning.
Uh-oh. I think I got confused with some background.
Okay.
Yes, Your Honor. Okay.
No worries.
Sorry about that.
No. This is your first appearance hearing for the Magistrate Court of Clayton County.
Esta es su comparecencia inicial en el tribunal, la sala menor del Tribunal de Primera Instancia del Condado de Clayton.
We're not here to determine your guilt or innocence.
No estamos aquí para determinar su culpabilidad ni inocencia.
We're here for me to tell you the charges.
Estamos aquí para que yo le informe de las acusaciones en su contra.
To set a bond.
Para que yo le imponga una fianza.
To give you future court dates.
Para informarle de sus audiencias futuras.
And determine whether you require the assistance of an attorney.
Y también para que yo determine si usted requiere el asesoramiento de un abogado.
Would you like for me to determine whether you qualify for the appointment of a lawyer?
Quisiera que yo determine si usted reúne requisitos para un abogado, señor. Yes.
Okay. I'm going to find you qualify, sir. I'm going to appoint a lawyer to represent you.
Determino, señor, determino que usted sí reúne los requisitos y voy a nombrar un abogado de oficio para usted.
And I want to advise you that during this hearing and all future hearings, you have the following rights.
Quiero informarle que durante esta audiencia y cualquier diligencia ulterior, usted tiene el derecho a los siguientes derechos.
You have the right to the presumption of innocence.
Tiene derecho a que se le presume inocente.
You have the right to indictment by a grand jury for most felonies or by accusation for misdemeanors.
Tiene derecho a que la fiscalía proceda en su contra con una acusación formal por el gran jurado cuando se trata de delitos graves o que procede en su contra con una acusación general cuando se trata de delitos menores.
And in your case, you're charged with a misdemeanor.
En el caso de usted, se le acusa de un delito menor.
You have a right to a speedy and public trial by jury.
Tiene derecho a un juicio público y sin demora ante un jurado.
You have the right to see, hear, and question witnesses who are called to testify against you.
Tiene también el derecho a ver, a escuchar y a interrogar los testigos convocados a declarar en su contra.
You have the right to compel the attendance of witnesses to testify on your behalf.
Tiene derecho a obligar que comparezcan testigos para que declaren a su favor.
You have the right to testify on your own behalf or offer evidence in your own defense.
Tiene derecho a declarar a favor propio o presentar pruebas en su propia defensa.
And you have the right to an attorney or to have an attorney appointed to you if you qualify.
Y tiene derecho a un abogado y un abogado designado por el tribunal si usted cumple los requisitos.
And in your case, I have appointed an attorney to represent you.
En el caso de usted, ya nombré un abogado para representarlo.
You're going to have a preliminary hearing date set for November 2nd at 8:30 in the morning, courtroom 201.
Su audiencia preliminar está programada para el día 2 de noviembre a las 8:30 de la mañana en la sala 201.
That date will get waived upon your bonding out and you'll get a new court date in the mail.
Esta audiencia se renunciará automáticamente una vez que usted salga en libertad de la cárcel y luego le mandará a notificar por correo de la próxima cita judicial.
Do you have any questions of me?
¿Tiene usted alguna pregunta para mí, señor?
Sí, para el 2 de noviembre tengo la corte, ¿verdad?
Yes, so on the 2nd of November is my court date, correct?
If you bond out, that date will get moved to some date in the future.
Si usted sale en libertad bajo fianza, entonces se pasará su cita judicial para otra fecha en el futuro.
Consider that date as a placeholder.
Esa fecha es como un lugar para marcar un espacio de una audiencia.
If for some reason you don't bond out, we've set a date for you to appear before a judge again, so you're not just sitting in jail.
Para que en el caso de no poder salir bajo fianza, ya queda programada una cita para que usted esté ante un juez en lugar de nada más estar esperando en la cárcel sin una audiencia. Yes.
Bajo fianza, ¿cuánto lo tendría para salir bajo fianza, ¿cuánto lo que tengo que pagar?
And in order to get out on bond, how much do I need to pay?
So this offense, the bond is automatically set at $500.
Esta infracción conlleva una fianza automática. Se determina automáticamente a $5,000, Your Honor.
500, sorry.
500, I'm sorry. Se determina automáticamente a $500, señor.
At one point, bonding companies would not set a bond that was less than $1,000.
Había un momento en que las compañías de fianzas no tramitaban fianzas que eran menos de $1,000.
I do not know if that's still the case.
Yo no sé si eso sigue siendo el caso.
But if they do not set a bond, well, strike that. I'm currently uncertain as to whether a bonding company will set a bond for a $500 bond.
De hecho, no estoy seguro si una compañía de fianzas tramitará su fianza como es solamente de $500.
Because that is essentially $50 for the bonding company.
Esencialmente, la tarifa a pagar sería $50 que usted pagaría a la compañía de fianzas.
You have 3 ways to post your bond.
Hay 3 maneras de pagar la fianza, señor.
You can pay the entire amount to the sheriff's department. They will hold it and return that money to you when your case is over.
Pagará el suma total a la comisaría del sheriff, guardará el dinero hasta que el caso se concluya, luego después le devolverá todo el dinero pagado.
You can go through a bonding company and they will charge a fee, which is generally a percentage between 10 or 12% of the bond.
Podría tramitar su fianza a través de una compañía de fianzas. Ellos cobran una tarifa que suele ser entre el 10 y el 12%,
And that fee will not be returned to you.
pero esa tarifa no se le devuelve aún.
If you own property in Clayton County that has at least 3 times equity or net equity of 3 times the bond amount, and in your case, that'll be a little bit more than $1,500, you can place the property up.
Y si usted es dueño de un bien dentro de los límites del condado de Clayton y ese bien tiene un patrimonio neto de por lo menos 3 veces lo que es la fianza, en este caso sería por lo menos 1,500, podría poner la propiedad como la garantía de su fianza.
And the more correct term is you can use the equity of the property to secure your bond.
El término más correcto sería que usted estaría utilizando el patrimonio neto del bien para asegurar su fianza.
The sheriff's department will place a lien on the property, and then they will remove the lien from the property when your case is resolved.
Entonces la comisaría del sheriff pondrá un gravamen sobre esa propiedad, el cual librará una vez que el caso se concluya.
Any other questions, sir?
¿Alguna pregunta más, señor?
Propiedad no tengo,
Well, property I don't have,
pero tengo ahorita acá en la máquina $500, lo puedo pagar yo ya para comenzar o no.
but I do have here like $500. I could pay it myself.
So what you would have to do, you would pay that to the sheriff's department, and they will hold that money and return it to you when your case is over.
Entonces lo que tendría que hacer es pagar ese dinero en la comisaría del sheriff, guardará ese dinero y luego se lo devolverá una vez que el caso se resuelva.
Okay. Sí,
Okay.
Ahorita los $500.
Okay, I can pay that now, the $500.
Okay. Any other questions, sir?
Bueno, señor, ¿alguna pregunta más?
No, está bien así.
No, that's fine.
Okay, so you're free to go back.
Está bien, señor, ya se puede retirar. Gracias.
Mr. Garcia. Mr. Garcia, sir, you're charged with 1 count of failing to yield at a stop sign.
Señor García, se le acusa de una infracción de no ceder el paso en un señal de parar.
The bond is going to be set at $500 for that.
La fianza para esta infracción es $500.
And you're charged with 1 count of driving a vehicle while unlicensed.
También le acusan de una infracción de conducir un vehículo sin una licencia.
And the bond is going to be set at $1,000 for that.
Y la fianza para esa infracción sería $1,000.
So that's a total bond of $1,500. You believe you can post that bond, sir?
Entonces, la fianza total sería $1,500. ¿Piense que podría depositar la fianza para salir, señor?
Ya mi familiar la pagó desde las 9 de la mañana, me parece.
Yes, my family has actually paid that since 9 this morning, it seems.
Okay. And that happens sometimes, sir, is because of just a number of people and moving things around. Sometimes people miss the cutoff time between court and bonding out.
Eso sucede a veces, señor. A veces por la cantidad de gente no se paga el tiempo a la hora límite para luego pasar a las personas detenidas a su audiencia.
Did you hear what I said to the other gentleman?
¿Escuchó lo que yo le decía al otro señor?
Sí.
Yes.
Do you have any questions of me about anything that I said to him?
¿Tiene usted alguna pregunta para mí sobre lo que yo le dije a él?
No.
No.
Okay, so you're also going to be in the position where your bond, once you bond out, your preliminary hearing date of November 2nd is going to get waived and you'll get a new court date in the mail.
Entonces, si usted está en la misma posición que él, entonces, una vez que salga en libertad bajo fianza, la audiencia que está programada para el día 12 de noviembre quedará renunciada y le mandará por correo la notificación de la nueva audiencia.
Okay.
Okay.
So if you don't have any questions, sir, you are free to go back.
Muy bien, señor. Si no tiene más preguntas, ya se puede retirar.
Gracias.
Thank you.
Okay. Let's switch over to the ladies' side. And Miss is going to work out well today. Miss Castellanos is actually the first person on the on the ladies' side, so we can move forward. You got to unmute on the ladies' side. Okay. Miss Castellanos, can you hear and understand the interpreter?
Señora Castellanos, ¿puede usted escuchar, oír y entender a la intérprete?
Sí, yes.
Yes.
Did you hear the conversation I had with the other gentleman about his rights?
¿Escuchó usted la conversación que yo tuve con los otros señores sobre sus derechos?
Sí, yes.
Yes.
Ma'am, you've been charged with 1 count of simple assault.
Muy bien, señora. Se le acusa de una infracción de agresión simple.
Your bond is going to be set at $3,000.
La fianza está fijada a $3,000.
I could not read the officer's handwriting as it relates to the victim, so I was unable to place a stay away provision on your bond.
No puedo leer bien la letra del oficial sobre quién era la presunta víctima, así que yo no puse en efecto una orden para prohibir contacto entre usted y él o ella.
Your preliminary hearing date is going to be set for November 2nd at 8:30 in the morning, courtroom 201.
Su audiencia preliminar está programada para el día 12 de noviembre a las 8:30 de la mañana en la sala 201.
And that date will be waived upon your bonding out and you'll get a new court date in the mail.
Y luego esta fecha quedará renunciada una vez que usted salga en libertad de la cárcel y le mandarás la notificación de su nueva audiencia por correo.
Do you want me to see if you qualify for the appointment of a lawyer?
¿Quiere que yo determine si usted reúne requisitos para un abogado? Yes.
Give me 1 second.
Permítame.
Ma'am, how much do you make per hour?
Señora, ¿cuánto está ganando por hora?
Ya 12 la hora.
12. $12 an hour.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you.
Usted sí cumple los requisitos y voy a designar un abogado para representarla.
Do you have any questions of me?
¿Alguna pregunta para mí, señora?
Nada más, ¿en qué momento puedo venir a pagar el bond? Mi tía va a venir.
Just when can they come and pay the bond? My uncle's going to come.
It will be today.
Sería hoy.
Okay, thanks.
Okay, that's fine.
Okay. Any other questions?
Bueno, señora, ¿alguna pregunta más?
No, todo bien, gracias.
No, that's fine. Thank you.
Okay, ma'am, you're free to go back.
Bueno, señora, gracias. Ya se puede retirar. Thank you, Your Honor.
Thank you, Ms. Tolles. Happy Monday to you. I hope
Happy Monday.
everything goes well.
I wish you the same. Have a great day.
You too. All right, let's start now. Are you Miss Laney?
Yes.
Ma'am, you're charged with one count of aggravated assault, one count of simple battery, one count of criminal damage to property in the second degree, which is also a felony, and one count of cruelty to children in the third degree, which is a misdemeanor. So this is something I've kind of agonized over this morning. I'm going to set a bond on these offenses. It's going to be a $10,000 bond on
10,000.
Don't
Man, y'all got me.
don't bring it up.
Ma'am, would you like it to be no bond?
Man, cause that's
Ma'am,
ain't right.
would you like it to be no bond?
No.
No, I'm seriously asking her, because if she thinks this is a discussion,
I'm
you
just
know.
saying, you saying $10,000. Who got that money? Come on now. I'm not
So,
trying to be funny on that.
ma'am, if you knew you didn't have that money, you should not have taken a knife and went after Mr. Randolph with the knife.
He cut me. It's on my finger. He cut me first. I picked it up from him and tried to cut him back. It's a whole video.
Ma'am, do you realize you just implicated yourself in a crime?
I'm just saying, he cut me first.
This is on the internet, ma'am. This is on the internet. This is live. We haven't even gotten to the point of talking about whether you want a lawyer, whether you want somebody to defend yourself. You're implicating yourself already. So we will have a discussion when I'm done telling you the decision that I've made, and I'm happy to have that discussion with you. So bond is going to be set at $10,000 for aggravated assault, $3,000 for simple battery, $5,000 for criminal damage to property in the second degree, and $3,000 for cruelty to children in the third degree. There's going to be a stay away provision on your bond to stay away from a Richard Randolph. Your preliminary hearing date is going to be set for November 1st at 8:30 morning, courtroom 201. The date will get waived upon your ability to bond out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
I didn't hear what you said the next court date was.
November 1st at 8:30 in the morning in courtroom 201 is the preliminary hearing. That date will get waived upon your ability to bond out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
I'm going to find you qualify, ma'am. I'm going to appoint a lawyer to represent you. Now, we can discuss whatever it is you want to discuss. This is the time to speak, ma'am. If there's anything.
I feel it's like, okay, so like, it's all start about my sister. My sister, my blood sister.
Hold on, ma'am. So what we don't do is have people talk about the facts of your case, because you have not had an opportunity to talk to a lawyer who is the person that's there to help you.
I don't even care no more. I really don't.
Just take a second.
So you're free to go back, man. You're free to go.
Okay. Well, please. Hey.
Well, sorry for that.
Not say a word. Hey.
Are you Miss Lowe?
Yes, sir. More.
Ma'am, you're charged with 1 count of driving under the influence of alcohol to the extent you were less safe driver, and 1 count of reckless driving. There's going to be a $5,000 bond set on the DUI charge and a $2,000 bond set on the reckless driving. So that's going to be a total bond of $7,000. Do you believe you can post that bond?
No, but I'm gonna try.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir, but my bond won't be waived, right? I still have a bond even in the process of you finding me a lawyer.
Yes, ma'am. Those two things have no impact on each other. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Your preliminary hearing date is going to be set for November 12th. I'm sorry, November 2nd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Do you have any questions of me?
Could you just repeat the bonds in total? Repeat.
Okay, so there's a $5,000 bond set for the DUI charge. There's a $2,000 bond set for the reckless driving charge. Okay, all right, ma'am, you're free to go back.
Thank you.
Miss Murphy, ma'am, you're also charged with 1 count of driving under influence of alcohol to the extent that you were a less safe driver, and 1 count of driving on the wrong side of the road. There's going to be a $5,000 bond set on the DUI charge. And there's going to be a $500 bond set on driving on the wrong side of the road. So it's going to be a total bond of $5,500. Do you believe you can post that bond?
No.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay. All right, ma'am, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date also set for November 2nd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you have any questions of me?
No.
Okay, ma'am, you're free to go back. Ms. Randolph, ma'am, you're charged with 1 count of giving a false name, address, or date of birth. Your bond is going to be set at $2,000. Do you believe you can post that bond?
Yes.
Your preliminary hearing date is going to be set for November 2nd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
How much do you earn per hour?
I don't even know because my job is not a regular job.
I'm sorry, you said your job is what?
It's not a regular job.
Oh, okay. All right, ma'am. I'm going to find you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes.
Yes, ma'am.
I was trying to see about my warrant.
Let's see. You were told that you had a warrant when you got booked in?
Yes.
Okay, let me see if I can see. Sometimes I can, sometimes I can't. You are Miss Randolph. Let's see. All right, so. I'm showing one cycle. Okay, well, maybe this is it. No, I'm showing on my end one cycle, which means one interaction or an interaction with the police, and it's from April 19th of 2019.
Yes, that's not a lot.
Okay. So it's showing that there's something pending there out of Clayton County, a criminal attempt charge. If the jail told you that that charge is pending, you can pretty much bank on it because they get the information, and you know they know things I don't know as it relates to people. So if they told you that, whatever they told you, you can pretty much take it to the bank. Did they, because all I'm showing is, it says a charge out of Clayton County Police Department. But I'm not seeing anything else unless I'm on the, hold on, maybe I'm wrong. Yeah, that's all I'm showing. But so it may be a warrant. If it's out of a municipality, like you got a speeding ticket or something out of
This charge is with Superior.
Okay. So it whatever they told you, like I said, you can pretty much take it to the bank because they have the up-to-date information and the more complete information.
Okay. So I can still bond out.
If there's a warrant for your arrest, the first thing you would need to do is bond out on this. That brings the warrant into play. If it's out of a wherever it is, if it's out of Superior Court, let's say it's a failure to appear or something like that, then you're going to have to go back before that judge in the court that the charge was pending out of. If you have a lawyer or had a lawyer, my best advice to you would be to contact that lawyer so the lawyer can contact the court and work something out so that you're not just sitting here doing dead time.
But I don't think that's gonna happen. That lawyer has not been helpful at all since day one. He never showed up. I sat in there the first time I sat in there longer than I was supposed to. And they told me, hey, he still didn't show up the day that I got out.
Yeah, it's as I just was told, you have a bench warrant out of Superior Court.
Yeah.
So that's most likely failure to appear.
Yeah.
And you're gonna have to deal with that before whatever judge is there.
Okay, but how would that go? Because if I did show up multiple times and they told me they wasn't doing my case, because that's the situation.
So, number one, Clayton County has what I call a forward-facing website. You can go to claytoncountyga.gov. You can click on the court records and you can put your name in there and it'll show information related to you or any kind of case that's pending.
Okay.
The dealing with the issue of the bench warrant, 9 times out of 10, it's a failure to appear, which Could be intentional, could be accidental. I don't know, but it's something that can be resolved, but you have to take the affirmative steps. Don't go through the, well, they said this, or he said that, or I called my lawyer didn't call me back. And you know, all that's going to do is leave you sitting in jail. Okay. So you're going to have to take some affirmative steps to make sure you know, deal with your life and keep yourself out of these situations. Okay. Anything else, ma'am?
No, thank you.
Okay, you're free to go back. Miss West? Ma'am, you're charged with 1 count of simple battery. Bond's going to be set at $3,000. You believe you can post that bond?
Yes.
There's going to be a stay away provision on this bond to stay away from a Chantel Hardy. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 2nd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No.
Okay. Do you have any questions for me?
No, sir.
Okay, ma'am. You're free to go back.
That was the last female, Your Honor.
Okay, thank you.
Sir.
Have a good day.
You too, Judge. Thank you.
All right, let's switch over to the men.
Mr. Adams,
Right.
you're up.
Sir, what's your last name is Adams?
Uh-huh.
Okay, on my sheet is ADMAS.
ADAMS.
I'm sorry.
ADAMS.
Okay. No, I was just saying on my sheet is ADMAS. So I'm going to strike through it and I'm going to write the correct spelling of your name. Sir, you're charged with 1 count of criminal trespass. That's a misdemeanor. Bond is going to be set at $3,000. Do you believe you can post that bond?
Nah.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Nah, just give me the time, bro. I'll just do it.
Again, I'm not here to determine whether you're guilty or innocent. I'm here to set a bond, give you court dates, set a lawyer, appoint a lawyer to represent you if that's what you desire. You want me to appoint a lawyer to represent you?
Today?
Yes, sir.
Nah, just give me the time.
Mr. Adams, I can't give you any time because that means that I've determined that you're guilty of the crime. So that's what I'm saying. I'm not here.
Sorry.
So, Mr. Adams, listen to me, please, sir. If it is your intent to plead guilty to this charge, I can appoint a lawyer for you that will walk you through that process. Okay? Today, I cannot do that. I am the best way to explain it is I'm a judge, but whatever I make a decision about today, a prosecutor tomorrow can make a different determination. Okay. So I'm basically, you know, I don't know how old you are, but people's court, and you're like, you're here and it's like dealing with basic things for the people. So what I am here for is to appoint you a lawyer to protect your rights.
All right, we could do that.
Let him finish.
Okay. I'm going to do that. I'm going to appoint a lawyer to represent you. There's going to be a stay away provision on this bond to stay away from an Audra Danner. Do you understand that?
But I have no money. You gotta do signature bond?
Okay, let me look, Mr. Adams. Like I said, I'm not here to tell you yes or no. I'm gonna look at this and I can tell you whether you qualify. So looks like you have 5 cycles in your criminal history, and pretty certain the my boss, the chief, is not going to agree to a signature bond. So I've appointed a lawyer to represent you. Said you're not going to be able to post a bond. Okay, I'll tell you what I'm gonna do. We're gonna split the baby on this one. I'm gonna set a $1,000 bond. But I'm gonna also set a stay away provision for you not to return to this location, this Quick Trip, 6801 Mount Zion Boulevard. So that puts you in a position of being able to post bond for like $100, but also it puts you in a position where if you return back to this location, you could face aggravated stalking charges, and which no bond is set, and you're sitting in jail. So that's what I'm gonna do, try to help you out along this path, but also you're gonna be in the position of understanding that I don't know what it is about this Quick Trip, but if you go back, you could be facing felony aggravated stalking charges. All right. Do you have any questions for me?
Like I said, I don't have any money for it. You said
Okay.
You said it was okay. I don't be released. That's all.
I'm sorry, sir.
What do you say? That it was okay that I don't have any money for a bond.
I reduced it to $1,000. Your bond, Mr. Mr. Bennett, I'm sorry, Mr. Adams, if you had not returned to this quick trip, we wouldn't even be having this conversation. So that's what I'm saying. I don't know what is so special about that place that it's enough for you to go to jail and you ain't got no money to bond yourself out. That doesn't make sense to me. I mean, hey, go to the Citgo, go to the Exxon, Amoco, wherever. Don't go back to the quick trip. It ain't worth you sitting in jail behind. Okay, sir. All right, sir. You're free to go back.
So if I don't have do the bond, I'll be.
So this last thing, because these are misdemeanor charges, the solicitor's office, these are relatively minor charges, and they'll have court on Tuesdays where they bring people in to do exactly what it is you're saying you want to do. I plead guilty, give me time, I'll be done with it. Because this ain't the crime of the century. This ain't OJ Simpson. This ain't, it's, you just gotta stay away from that place, please. It ain't worth it. All right?
Yeah. So you're
yeah, he's free to go back.
Mr. Bennett,
Mr. Bennett, sir, you're charged with 1 count of criminal damage to property in the 2nd degree. This is a felony offense. Your bond is going to be set at $5,000. Do you believe you can post that bond? I'm sorry, sir.
Yes, sir.
There's going to be a preliminary hearing date set for November 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. There's going to be a okay. Would you like for me to see if you qualify for the appointment of lawyer, Mr. Bennett? I'm sorry, sir.
Yes, sir.
Okay. How much do you make per hour?
You say about 9.
Okay. I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, sir. You're free to go back. Mr. Buffington. I'm sorry, sir, you're charged with 1 count of giving false name, address, or date of birth. Bond is going to be set at $2,000. You believe you can post that bond? I'm sorry, sir. I can't hear you, Mr. Buffington.
You said $200 bond. Will I be able to pay a post bond?
So it's $2,000. If you go through a bonding company, you're going to pay a percentage, which is generally about 10 to 12%. So that'll put you in that range. Okay. If that's what you're asking.
Yes, sir.
Okay. Your preliminary hearing date is going to be set for November 2nd at 8:30 in the morning in courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You didn't fill out the form. Are you currently working, Mr. Buffington?
No, sir.
You said no?
Yes, sir.
Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Probably not.
Okay, sir, you're free to go back. Mr. L.
Yes, Your Honor.
Mr. L, sir, you're charged with 1 count of criminal trespass, 1 count of battery, 1 count of false imprisonment. The criminal trespass and battery charges are misdemeanor. The false imprisonment is a felony charge. You're gonna have a $3,000 bond set on the criminal trespass, a $5,000 bond set on the battery, and a $5,000 bond set on the false imprisonment. So that's going to be a total bond of $13,000. Do you believe you can post that bond? Okay. There's going to be a stay away provision on the bond to stay away from a Michaela Pegisi, P-E-G-E-E-S-E. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for November 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I'm not sure if I'm able to afford the bond. So,
Okay. So what I would suggest you do is contact the bonding companies. I think there are 4 or 5 bonding companies that are authorized to write bonds here in Clayton County. Contact those companies. Tell them your name. Tell them your charges. Tell them what your bond amount is. Their business model is to help people get out of jail. So they will work with you, but you have to speak to them. Okay.
okay.
Anything else, sir?
I wanted to see if I could get a signature bond. Qualify for it.
Okay. I'm gonna treat you as fairly as I treat everybody else. I'm gonna look at this. Because the process is I don't make the decision. My boss makes the decision. But in having these conversations with her, I kind of have gotten to understand what she considers to be signature bond worthy offenses. And I'm going to tell you just off the charges these are not the type of offenses that she will look at and say, oh, let me get this person a signature bond.
No, I don't think I would be able to afford it, honestly.
I'm sorry, sir.
I still don't think I'll be able to afford the bond.
You said you do not believe that you will be able to afford the bond. So the problem, especially with charges like this, Mr. L, is that you are in complete control. You did, based upon the allegations, you did the things that got you here. Speaking to a judge, saying, I cannot afford to bond myself out of jail. The question comes to my mind all the time. What were you thinking And this is your presumed innocence. So it's not like I'm presuming that you did it. The bond that I've set for you is the same bond I set for everybody. So you're not being treated any differently. As an adult, you have to be in control of your life.
I wasn't able to write a statement and tell my side of the story. I don't think.
Yeah. From what I'm looking at, Mr. L, I don't think you're gonna qualify from the chief's criteria about getting a signature bond. The process is that your case gets carried over to the next day so that I can have a conversation with her this evening about your request, and she makes a decision. And so I'm straight up and honest with people that, hey, you got a bond, you need to try to make that bond. I'm not gonna essentially, I'm not gonna lie to you and tell you that, hey, you got a great chance that this is gonna happen. It doesn't work that way. So if you want me to carry it over, knowing that she may say no, and you spend another day in jail for no reason.
It's fine. It's fine.
I'm sorry.
I said it's fine.
I don't understand what you're saying when you say that's fine.
It's all right. It's fine. Like I'm saying, like I don't need it. I understand what you're saying.
There's Mr. The way that they have your date of birth written is that you were born in July of this year. What year were you born?
2001. July 27, 2001.
Okay, they got you as being born in 2021. Mr. L, life doesn't get easier, it gets harder. And I've had this conversation with some young men when they're like, oh, it didn't happen that way, it didn't do this. And I was like, so you're telling me that the person that you were in a relationship with, she's lying on you and got you in jail? So if I put the fact that I'm putting a stay away provision on the bond is actually helping you, because you have apparently or cannot discern the type of people that you need to be around and not be around. And all I can tell you, sir, is the bond's going to stay the way that it is. I've appointed a lawyer to represent you, and I would encourage you to contact the bonding companies to make arrangements to bond out, and then don't put yourself in this position ever again in your life.
Thank you. And how much was bond again? I'm sorry.
So it's $5,000 for battery, $5,000 for false imprisonment, $3,000 for criminal trespass, for a total bond of $13,000. Okay, so that's going to be my ruling. That's what we're going to do, and you're free to go back. I'm sorry, sir.
Repeat the dates for my next court date.
November 1st, 2021, courtroom 201 at 8:30 in the morning.
Okay, thank you.
Okay. All right, sir. Free to go back. Mr. Hilton.
This nigga profit. I swear to God,
Mr. Hilton, sir, you're charged with one count of simple battery. I've set the bond at $3,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond to stay away from a Giovanni Carter. Do you understand that?
Yes, sir. A question with the stay away. She's at my house, so how would I get her out of my house?
I'm gonna come back to that. Okay, I'm gonna tell you some things, and then we'll have a discussion. Okay, so your preliminary hearing day is going to be set for November 2nd at 8:30 in the morning, courtroom 201. There. Well, would you like for me to see if you qualify for the appointment of a lawyer? I'm sorry, sir.
Yes, sir.
Okay. How much do you make per hour, Mr. Hilton?
$28.
Okay, you still qualify. I'm going to appoint a lawyer to represent you. Now, to answer your question directly, does Miss Carter live at your house?
Yes. But her name ain't on the lease.
Mr. Mr. Hilton. So this conversation go a whole lot easier if we are like question, answer, question, answer, question, answer. Does she live at that house?
Yes.
How long has she lived at that house?
The past year.
Okay, so you have invited her in, and she, under the law, has an expectation that that's her residence. So, under current law, you are now, your designation is offender, and her designation is victim. The law does not allow a judge to kick a victim out of a house because an offender did something to the victim. So and the reason I place it in those stark terms is because boyfriend, girlfriend, husband, wife, you know, situationship, whatever names you want to place on it. What the law places on it is offender victim. Judge can't kick a victim out. She can move if that's what she so desires. If she does not desire to move, you move. Okay? And that is the way the law is. So when you're, and you know, I swear to God, I feel like I'm like on a soap opera sometimes when I'm sitting here and I have these discussions. You made the decision to move a person into your house that was not your wife. And there were no like rules attached to that. Because you made poor decisions, it does not place on the judge an obligation to fix your house, if that makes sense to you.
I got you.
So what you can do, when you leave, you can make arrangements with the sheriff's department so that you can take stuff out of the house. I have no idea the stage of the relationship that you have with Miss Carter, but if she wants to stay in that house and kick her feet up while this stuff is pending, she has every legal right to do so. And all you can do is make your situation worse if you try to move her out of that. Okay? If she does not choose to voluntarily leave or, or whatever, that tells you all you need to know about that relationship and how far it's going to go, which is not far. So all I can do is tell you water's wet and fire is hot. And and you got to be the person that if you want to test it out. But you're on that line. Okay. And I hate to speak to you in those stark terms, but yeah, you're in a pickle. You're in a pickle.
So what would I, with the sheriffs and get my stuff, so I would need to call like up to the sheriff's department and arrange a time to go pick up my stuff?
When you're going through the bonding process, have the conversation with the sheriff's office personnel. They will tell you what you need to do. Follow their advice. Do what they tell you to do. And I hope that this is just a blip in your relationship and you and Miss Carter can get married, have children, have a lovely life. That's what I hope for you.
One more question. So I can move everything out of there, pretty much. Anything that's mine.
Well, see, this is the thing. Sheriff's Department, they're not going to be there like for 6 hours while you're moving your life out. Generally in these situations, what I've observed is that there is an imbalance is what I would say. And so a person is living with another person because they can't afford to live on their own. And sometimes that's the thing that leads people to kind of move back to center, because you're not under any obligation, because you aren't married, to pay bills. And there are certain situations where leases can be broken and all of that kind of stuff, but that you're gonna have to speak to a lawyer about that.
All right.
Okay, sir?
Yes, sir. Can you repeat the date one more time?
Yes. It is November 2nd.
November 2nd.
Yes, but sir, that date, once you bond out, that date is going to get waived and you'll get a new court date in the mail.
Okay, I got you. Thank you, sir.
All right. You're welcome. Have a good day. Mr. Lee.
Your Honor, I'm in my proper person status.
I'm sorry, sir.
I'm in my proper person status.
Okay. So Mr. Lee, you've been charged with speeding between 15 and 24 miles over the speed limit, driving a vehicle without a license, possession of marijuana less than an ounce, possession of a firearm by a convicted felon, and theft by receiving stolen property. So the last two charges are felony offenses. For the speeding, there's going to be a $1,000 bond. For the driving a vehicle without a license, there's going to be a $1,000 bond. Possession of marijuana less than an ounce, there's going to be a $1,500 bond. Possession of a firearm by a convicted felon is going to be a $5,000 bond, and theft by receiving stolen property, there's also going to be a $5,000 bond. So you're going to have a total bond of $13,500. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for November 1st at 8:30 in the morning in courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail Would you like me to see if you qualify for the appointment of a lawyer, Mr. Lee?
Sir, I have a appointment already.
Okay, that's fine. Do you have any questions of me, sir?
No, sir. The only question I have for you is peace on your journey.
Thank you. I appreciate that. I need everything. All goodwill that can come my way. I need it all. Thank you, sir.
Stay safe, bro. Stay safe.
Mr. Mays? Mr. Mays, sir, you've been charged with one count of public indecency, one count of use or possession of drug-related objects, and one count of possession of marijuana less than an ounce. These are all misdemeanor offenses. The bond for the public indecency is going to be set at $2,000. There's going to be, actually, strike that. It's going to be $1,000. The bond for use of possession of drug-related objects is going to be set at $1,500. The bond for possession of marijuana less than an ounce, it's going to be set at $1,500. So that's going to be a total bond set at $4,000. Do you believe you can post that bond, sir? Your preliminary hearing date is going to be set for November 2nd at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? I'm sorry, sir?
Yes, sir, please.
Okay. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me, Mr. Mays?
Do I qualify for a vet court?
I'm sorry, sir?
I qualify for vet court. I'm a veteran.
Judge Mays, Jesus Christ. Oh, why am I blanking on his name? I'm blanking on his name right now, but they have the Veterans Court in Superior Court and not State Court. So they're trying to set it up in Superior Court. So I don't think that you would automatically qualify for that. But I'll tell you this, the judges are, especially with all this stuff going on with COVID, backlogs, all this stuff, judges are trying to get creative in how to reduce and move things along. You should speak to your lawyer, and I'm not going to say like too much, or I'm not going to ask you to say anything, but with the possession of marijuana, speak to the lawyer about the possession of marijuana, and the lawyer may be able to have a discussion with the solicitor and your judge, and you may end up having a favorable outcome in your case. But just speak to your lawyer about that, okay? All right, sir. Any other questions?
Okay.
All right, free to go back. Are you Mr. Mitchell?
Yes, sir.
Mr. Mitchell, sir, you're charged with one count of battery and one count of aggravated assault. I've set a $5,000 bond on the battery charge and a $15,000 bond on the aggravated assault charge for a total bond of $20,000. Do you believe you can post that bond?
Sir.
There's going to be a stay away provision on the bond to stay away from a Shanita Carton. You understand that?
Yes, sir. I also have a question on that too.
Okay, we'll circle back around to that. Your preliminary hearing date is going to be set for November 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? I'm sorry, did you say yes?
Yes, sir.
Okay. All right, Mr. Mitchell, you do qualify. I'm going to appoint a lawyer to represent you. Now I'll cut you off. Will you tell me what your question was?
It's also like the same thing with Jimmy, but the apartment's in my name. She's literally been there for about 2 weeks, literally. And I need to be able to try to push her out of her name is not on the lease, no bills, nothing. I've been keeping track. Literally, she's been staying in my apartment for 2 weeks. How would I go about pushing her out on that?
The short answer is you're going to have to talk to your lawyer. The long answer is generally, when a person is allowed to come into a housing environment with the intent to stay there, you have to go through the dispossessory process. That's the general part, because that's the way that you legally remove some person from your home.
So basically, I gotta get like an eviction notice to evict her out.
Well, the thing and why I say it's general is because I would have to sit down with you with the paperwork and what was said, what happened, when did it happen, how did it happen, and go through that process to give you an answer that I would be comfortable with as a lawyer, not getting sued because I'm giving you bad advice. So in this little setting, it's just not, it's not conducive to receiving good advice. So it's typically, I tell people, if you're gonna have somebody move into your place, that person better have a ring on their finger. And if they don't let them move in, because it ain't nothing good that's gonna happen from that. When or if things go bad, because all relationships have rocky roads, bumps. You know, I've yet to see anybody that has been in a relationship where they ain't been mad at their significant other for one reason or another. And when you just let people in your house, when those bumps come up, you just basically sign yourself up for a whole lot of heartache. Okay.
Yes, sir.
Any other questions, sir?
No, I did have to talk to my family about trying to get her out. That's it.
Yeah, I mean, talk to your lawyer. Talk to your lawyer, and that's because it's some people, she may be tired of you, and she may be packing her stuff as we speak, and she's gonna be out the door by the time you bond out and get home. So, so that's what I'm saying. It's like, as a judge, I can't tell you what she's doing, and because I don't know her, I don't know you. But I can tell you general principles, and that's it.
Yeah.
Okay, sir. Have a good day. Mr. Nelson.
Yes, Your Honor.
Mr. Nelson, sir, you're charged with 2 counts of criminal trespass, 1 count of simple battery, and 1 count of obstructing an officer. There's going to be a $3,000 bond set on each criminal trespass charge, a $3,000 bond set on the simple battery, and a $2,000 bond set on the obstruction of an officer. So that's going to be an $11,000 bond. Do you believe you can post that bond, sir?
I believe so. Yes, Your Honor.
Okay, there's going to be a stay away provision on the bond, stay away from a Caroline Morales. Do you understand that?
Yes, Your Honor.
Your preliminary hearing date is going to be set for November 2nd. at 8:30 in the morning, courtroom 201. And that, I'm sorry, sir.
I didn't say anything.
Oh, that date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay, you do qualify, Mr. Nelson. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor, thank you.
Okay, sir, you're free to go back. Okay, Mr. Payton, you've been charged with one count of violation of family violence ordinance is the way that it's written, but looks like it's a family violence order. This is a felony offense. Your bond is going to be set at $5,000. Do you believe you can post that bond?
Sir.
There's going to be a stay away provision on the bond, to stay away from a Chelsea Simpson. Do you understand that?
Sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir. And also, is it possible if I'm able to get a signature bar? Appearing that it's my first time or first offense, or anything dealing with jail.
Okay, let me look. Let me see. I'm going to look it up, but I'm going to tell you that this is generally not the type of offense that the chief would agree to a signature bond. Primarily, it's one of those things of based upon the allegations. These are things. Well, I'll say it in a different way. The things that just in conversations with my chief, the things that she looks at as cases that are eligible for signature bonds, or like a college student smoking marijuana, getting arrested, it becomes more difficult when you're talking about adults and the things that they're doing. I'm sorry. The paperwork's kind of organized a little bit differently today, so it's taking me a little bit longer to get to it. All right, here we go. Mr. Payton, you got arrested in November last year.
No, it was in 2019. It wasn't in 2020. And that was a traffic violation.
What I'm looking at is that There's possession or use of drug-related objects and driving while license suspended or revoked. You got 7 days. Driving without a license. So I don't think that's going to happen, Mr. Payton. So set the bond at 5,000. And you let's see. You wanted me to appoint a lawyer, correct?
Yes, sir.
Okay. How much do you earn per hour?
$12. I mean, it just depends now.
Okay. I'm going to find you qualify. Sir, I'm going to appoint a lawyer to represent you. Your preliminary hearing date is going to be November 1st, sorry, at 8:30 in the morning, courtroom 201. Do you have any other questions for me?
Sir.
Okay, sir, you're free to go back.
Durant.
Hi, sir. I am aware of all of my charges. My name is Faishan Ramsey. I am a community leader within the Zone 3 committee within the city of Atlanta. I do study law, so I am aware of the law because I kind of seem to get a little frustrated today. So I'm not going to waste your time. So for the nature of my charges, there's multiple conflicts in it. As the accusation was reported weeks before the arrest, the police officer did not take the warrant out until.
Wait.
Mr. Ramsey, can I stop you real quick? I requested additional information this morning because I didn't get the warrant, and I was told that you went to preliminary hearing on July 28th.
Okay.
I'm sorry, you went to first appearance on July 28th. And that preliminary hearing was said and bond was denied. So we have been just communicating back and forth as to, we don't even know why you're on this calendar.
Okay, all right, so my preliminary, you set my preliminary for today, the 13th, and you set my bond hearing for this 17th. And these, far as the warrant process, the warrant wasn't issued until the detective was aware that I was running for the mayor of Atlanta.
Hold on, let me stop you, sir. Your preliminary hearing date was set for today.
Yes, sir. It was.
So you should not be before me. You should be.
That's what I told them. I'm supposed to be in preliminary right now. I did not sign anything to waive my right for preliminary. I did not waive my due process.
No, I mean bond was denied, so you're guaranteed a preliminary hearing. This is Mr. Ramsey. This is what I'm going to do. I wanted to speak to you because I wanted to try to see what happened. I am going to. It may be too late to get you on today. Do you have a lawyer?
Sure, sir. See, the attorneys I hire is very expensive. So I know that this is no case to take the trial. So I wanted to go to the preliminary hearing to see if they wanted to take it to trial instead of me paying $100,000 for a case that's not even going to go to trial, sir. What judge issued this warrant? Because under 17-4-40, there was absolutely no evidence to sign this warrant at all. I have security cameras and I have parents who all have access. The day I was arrested, that this is not true.
So Mr. Ramsey, there's a probable cause standard, which is basically 51%, meaning it could have happened. Not that it did, but it could.
But I have provided security cameras that showed that it was 100% did not happen. And the detective was aware of it. And see, I have businesses within the city of Morrow. So me in the zoning with the city of Morrow already has conflict. So it seems like there's a vendetta against me and my business.
So Mr. Ramsey, that could be 100% true. And these charges could be 100% true. Both of these things could exist in the same space at the same time. Okay, that's why you get a lawyer. That's why you put your case together. That's why you defend yourself. Okay, because I
asked what judge signed this warrant.
I don't have the warrants. That's what I'm telling you. That for today. Now I can go back. Hold on. I'll do this. Let's have Mr. Ramsey have a seat, and let me finish these last individuals, and we'll bring him back up. Okay, Mr. Stevens.
Yeah.
Mr. Stevens, sir, you're charged with 1 count of battery, 1 count of criminal trespass. There's going to be a $5,000 bond set on the battery charge and a $3,000 bond set on the criminal trespass charge for a total bond of $8,000. Do you believe you can post that bond?
And it was my house, and the criminal trespass is my house, so how could it be trespass?
Okay, so the allegation in your particular case is that the way that you committed criminal trespass is by denying Keisha Varner entry into the residence.
Right, because she don't live there. I let her stay there for two nights. That's it.
So, I mean, you've heard this is the third time that we've had this issue come up today, right? Have you been listening to?
I heard the same case on. Because I got nobody outside to sign me out or nothing. Is there any way I could sign myself out?
Is there any way you can do what?
Sign myself out here. I don't have nobody on the outside to go to no bonds or nothing. I ain't got no people.
Mr. Stevens, I'm going to tell you what I've told the other gentlemen. Contact the bonding companies and make the appropriate arrangements. Make the appropriate arrangements that you need to make, and in the future, don't allow people into your residence that you don't trust. I mean, it's
okay. If I can
Let her finish.
Okay, excuse me.
So, Mr. Stevens, see, the thing is this: is that nobody lives a consequence-free life. We make poor decisions, bad things happen.
Right.
For everybody. Not just you, everybody.
I know this, I'm 63 years old. But look, can I ask you this? If
Yes, sir.
I ain't got nobody out there, then I'm gonna have to do the time in here until y'all let me out. So how much time will that be? Because
So these are charges that can be resolved through the jail court proceedings that they do on Tuesdays for misdemeanor charges. So the thing is this, Mr. Stevens, I don't know you, I don't hate you, I don't have any axe to grind against you. Decisions that you've made and the people that you've brought into your life that may have led to these kind of outcomes, those are things that you gotta, as they say, you gotta eat that. You gotta take that. So don't come asking other people to help you out of the bad decisions that you were making. Because if you had called me, which I know we didn't know each other, when you were saying you're gonna bring this lady in your house, I would have said, don't do it. And I'm gonna tell you in the future, moving forward, now that we've met, do not do it. It never ends up well. Okay? It's you know, it doesn't end up well. So you got to take those steps, sir. Would you, let me see. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah, and also, I mean, I have to sit in there until y'all let me go because I can't bond out.
No, you don't have to sit in there.
Well,
Thank you, Miss Adamson. You have the ability to bond yourself out of jail.
I want to do that now.
Mr. Stevens, you said you have a house, correct? Or residence, correct?
The house is left to me, yeah.
I'm sorry?
It's left to me, my brother passed away, and I'm in charge of the house, yeah.
So you had enough of a place where you could bring some lady in to come and live with you. And because of that decision, you're now sitting here before me. I think you can figure it out, Mr. Stevens. I really do. And I hope you learn the lesson.
Yeah.
Okay.
Okay, so
all right, I'm gonna appoint you a lawyer, sir, and you're gonna be free to go back.
Okay. Okay, go. So I sit in here until y'all get in touch.
Or you make bond.
I can't make bond because I don't have nobody on else.
I mean,
so
Ms. Stevens, Ms. Stevens, I hope that that's not the outcome of this situation.
So it's the second is the court date. I gotta stay a whole month before I get out.
Mr. Stevens. All right, let's do this mental exercise. Let's go back to you were arrested yesterday, okay? And based upon an allegation that Miss Varner made, correct?
Right.
And according to you, you let Miss Varner in your house on the 10th or the 11th.
Right. Yeah.
How long had you known her before you let her in your house?
3 or 4 years.
Why did you let her in your house?
Because she got put out where she was at.
Why didn't you leave her where she was at?
She didn't have no place to go outside.
And based upon that, you are now where?
In trouble because of it.
So shouldn't she be the person that is trying to help you get out of this?
She ain't got nothing. She's hungry.
No, that is not answering the question. The lady that you've known for 3 years, you let in your place, and 3 days later you're out. Wow. Is it possible that in her mind, that's what she was setting you up to do all the time? And you just fell right into it with a smile on your face, probably. Hey, I don't know you, you know her. Because of your interaction with her, you are now before me. So let's level ourselves and think about who made the poor decisions along the way. Wasn't Judge Gardner, wasn't a deputy sitting next to you. It was you. It was you. So come on, Mr. Stevens, you don't play that game of oh man, I'm just so I'm that. As a guy, I have a pretty good reason to believe why she moved in your place. And I think all the guys who are listening to this, as the preacher would say, under the sound of my voice, they know why that lady was in your house. And that lady played you. And now you're over here begging me to do something that under the law I can't do.
Okay, so can I ask you one thing? So it's a total of 800 for me to get out.
Sir,
5, you said 5.
when you post bond, you will get out of jail. I cannot say that any more plainer than I've said it.
That bond price is 800.
It is the same bond that I set for every person charged with battery, every person charged with criminal trespass. Actually, you know what? I actually set your bond a little bit higher than what I would normally do for criminal trespass. Because in this instance you're leaving a person out. So I'm going to reduce it down to $1,000. Okay. So that's $6,000 total, Mr. Stevens. But sir, you're going to have to make better decisions. Okay.
Is it 600 to come out?
Yes, sir. All right. Free to go back.
Okay, if I don't come up with the 600, I have to stay in there until you figure out that.
Correct.
You need to call the bonding companies because some of them will place you on payment plans. They will work with you, but you got to make them steps.
Okay. All right. Okay.
Mr. Suri.
Moving, Your Honor.
Sir, you're charged with 1 count of battery, 1 count of obstructing an officer. You're gonna have a $5,000 bond set for the battery and a $2,000 bond set for obstructing an officer for a total bond of $7,000. You believe you can post that bond?
Yes, no, Your Honor.
Okay. There's gonna be a stay away provision. Is written as Anderson, but it looks like son from the officer's handwriting. Anderson Lewis. Do you understand that?
Yes, Your Honor, I understand.
There's going to be a preliminary hearing date set for November 2nd at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay, I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, Your Honor. Well, what was the first charge, Your Honor?
Battery.
Battery?
Yes, sir.
And was that a misdemeanor or a felony?
They're both misdemeanors, and the allegation is that you struck Anderson Lewis on the left hand, causing visible bodily harm. that resulted in a laceration to the index of the middle finger.
Excuse me, Your Honor. I never.
So Mr. Sir, we try to discourage people from talking about the facts of their case until they've had an opportunity to speak to a lawyer, because we don't want you to unnecessarily.
Incriminate myself.
I'm sorry, sir.
You wouldn't want me to incriminate myself.
Exactly. And so.
But in this situation, Your Honor, I just want to tell you this, like that I.
So, Mr. Suri, I think the thing that you're not getting is, unless you've had legal training, you really don't understand. There could be a tacit admission where you say, I was at this place and not that place. And that places you in a box, because if there's no proof that you was at that place rather than this place, that attacks your credibility. So the jury can then, or anyone else can presume, because you lied about one thing, and not that you even lied, but they believe that you lied about one thing, they would say, well, he may be lying about other things. So as far as I'm concerned, sir, you're innocent. Everything I do here is just to set bond, set court dates, move things forward. Okay? There's nothing you can say that's going to change my mind about anything that I've read in your case. So that's why it's just, as I normally say, speaking to me about your case is like talking to that wall. Okay?
I would like to ask, can I get is a signature bond available in my situation, Your Honor?
Hold on. I'm gonna look. I give everybody the respect of looking it up.
Also, Your Honor, I was just recently in the Army, and I just came home from the Army from a vacation on like a because I'm going through some medical problems, and I just got caught up.
Mr. Siri, stop speaking. I just told you, speaking to me is like speaking to the wall, and you just keep talking as if whatever you have to say is going to change my mind. You've asked for me to look, and I'm looking. And once I pull your criminal history up, I'll ask you questions. Okay, so Mr. Siri, I can tell you, you're not gonna get a signature bond. You got arrested in 2018 on simple battery, criminal trespass. You were convicted on February 6th of 2018 on the criminal trespass and battery, family violence, and got first offender treatment. Looks like it got 12 months probation, a $300 fine. What is it that you're saying that says that you're a person that should get an OR bond?
Because Your Honor, I recently, in November of last year, I sworn into the Army of the United States, and I plan on going back to the Army of the United States this year, Your Honor. I plan on joining the Army like in like a week or two, and I was walking home, and a bad situation happened with some random man was harassing me.
Yeah.
So Your Honor, in 2018, me and my little brother, we had in that altercation, he had assaulted me, and I'm the only one who went to jail for it, and it was no video footage to prove my innocence, but I was innocent the whole time, Your Honor. So that's how I was asking you for a bond, signature bond, because I know that I'm innocent, and I know that I'm going to go join the U.S. Army.
No, I've heard that you're joining the Army, and you believe that what happened before was not necessarily fair, or it wasn't what took place. But all I'm telling you is that that doesn't qualify you for signing your name out in you're walking out of the jail.
And all I do is work for my family and take care of my family. I'm the youngest son, so it's so much I have to do. I have to pay rent for my mom and my older brother, and I'm the youngest son. I'm 16 in the Army, 17. I was just 20 years old in the Army. Like, I'm doing the best I can. I'm walking home and some dude, this random dude, is harassing me. You know what I mean? That's why I asked you for a signature bond, just to show you like I'm innocent. I'm innocent, and I'm gonna go out and I'm gonna work harder.
I understand. I've heard you. I disagree with you, and I've made my decision. Okay?
Yes, sir. Thanks, sir.
Okay, sir. You're free to go back.
Mr. Walker, Armani.
Right there.
Mr. Walker, sir, you're charged with one count of public indecency. The bond is going to be set at $2,000. Do you believe you can post that bond?
Public decency for the airport's incident.
Sir, that's what you've been charged with. I didn't charge you with that. I'm here to tell you what they charged you with. Would you like me to appoint a lawyer to represent you?
What's the like what's going on? What's the consequences and stuff like that?
Can you explain yourself a little bit?
As far as like me doing the stuff I did for my charge, like you said,
So this is a misdemeanor offense. The maximum time in jail is 12 months. The maximum fine is $1,000.
Did I spend $1,000 already?
Mr. Walker, I don't know what you paid. Okay, like if you've posted bond or you've done whatever, that doesn't equate over to what any fine that you may get from being convicted of this offense. The maximum fine is $1,000. The maximum amount of time is 12 months. Whether that happens in your case, maybe, probably not. I'm not the prosecutor. I'm not the person that makes that determination.
I have no money.
I'm sorry, sir.
I have no money.
Ouch.
I got about $100. That's it, sir. I have an attorney already, but
Okay. You can afford an attorney, but you only have $100.
I can't afford my attorney, but he could represent me one time for like 100 probably. But I can't fly him out.
Okay, Mr. Walker, let's start over. You're charged with public indecency. The bond is $1,000. Can you afford to post that bond?
$1,000? Oh, yes.
Okay. Would you like for me to appoint a lawyer, or are you going to go with the other lawyer that you have?
I have the money, so I'd like for you to appoint my lawyer, because if I use my lawyer, then, you know.
Okay. I'm going to take that as a yes. Your preliminary hearing date is going to be set for November 2nd at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. John Walker. So you're charged with 1 count of violation of Georgia Controlled Substance Act, 1 count of possession of a weapon during the commission of a crime, 1 count of criminal trespass, 1 count of carrying a pistol without a license, which is a misdemeanor, 1 count of driving a vehicle with no insurance, and a 2nd count of possession of a firearm during the commission of a crime. So there's going to be a $3,000 bond on possession of marijuana more than an ounce, a let's see, $5,000 bond for possession of a weapon during commission of a crime, $3,000 bond for criminal trespass, $3,000 bond for carrying a pistol without a license, $1,000 bond for driving a vehicle without insurance, and a $5,000 bond for the 2nd drug offense. So that's going to be a total bond of, let's see, $10,000. Yes, sir. Do you believe you can post that bond?
Yes, sir. But real quick, I know you said don't discuss the case, but if the vehicle wasn't being operated, does that count as operating without?
So the state has to prove it. They, from a probable cause standpoint, it's a lesser standard that can get you convicted. So you can get arrested if you're sitting in a car and you're drunk, right? You can get arrested for driving under the influence of alcohol, but it doesn't necessarily mean you're going to be convicted of that. State has to prove it, but the officer can say, look, I touched the hood was hot, the person's sitting in the driver's seat, person's passed out, they fail these field sobriety tests. That led me to believe this person was driving the vehicle under the influence of alcohol. Doesn't mean you did it. Takes a higher level of proof to convict you. Okay. So your preliminary hearing date is going to be set for November 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail.
Wait, can you say it again for me?
November 1st at 8:30 in the morning, courtroom 201. But that date will get waived upon your bonding out, and you'll get a new court date in the mail.
You said my bond was 10,000?
No, it's going to be 20,000.
That's all.
Do you want me to see if you qualify for the appointment of lawyer? Or do you have your own lawyer?
I got my own, but can you see if I qualify for signature bond?
I'm gonna guarantee you that Chief is not gonna grant that. Okay, sir, you're free to go back. Mr. William.
Yes, Your Honor.
Mr. Williams, sir, you're charged with one count of entering an automobile. Bond is going to be set at $7,000. Do you believe you can post that bond?
Can I apply for the signature bond?
Hold on one second. No, you're not gonna qualify for a signature bond under these circumstances. You're gonna have a preliminary hearing date set for November 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. This is a felony offense, so you need to be aware of that. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, with the 12% when you take off the bond.
So it'll be around $700. Well, I'll say as a wide estimate, between $700 and $850. $850, yes, sir.
Okay.
Okay, all right, sir, you're free to go back. All right, we still have Mr. Ramsey there.
Yes, Your Honor.
All right, so Mr. Ramsey, I was sent your warrants and your information. You know what you've been charged with, so I'm not going to discuss that. And the judge who signed the warrants was Judge George, and they were signed on July 27th.
20 what?
27th,
Okay.
27.
What kind of judge is Judge George?
She's the presiding judge of magistrate court.
Okay, all right, sir. So there is something I would like to state, since I am considered in this case as a school administrator, 17-4-40, to issue a warrant for the arrest of a police officer, or school administrator. The warrant must and only could be signed by a superior court judge. So that judge is not authorized to sign this warrant.
So all of us, one of the base qualifications to be a magistrate judge in Clayton County is that you also have to be eligible to sit as a superior court judge, because there are a number of duties that the superior court judges designate to magistrate court judges. So we all have to have been in practice for at least 7 years. And we
Okay,
all
so is
hold on. We all have to be qualified to be a Superior Court judge. Okay, so go ahead, sir.
all right. So is Judge George assigned by the court, the state, as a Superior Court judge of?
All of us are. All of us are. The at the beginning of each year, the chief judge of Superior Court, she does an order, and
What's that?
that's Geronda Carter.
Okay.
She signs an order, and outside of the typical magistrate court duties, we can only do what we've been designated by the Superior Court judge to do. Judges, because they all
So the warrant was signed on July the 27th. That was at 2:37 p.m., right?
Yes, sir.
Okay. I have that detective's on security camera footage at 11:37 a.m. He pulled up at my community center that I own on Jonesboro Road, right next to Clayton State. I own the 13 Love Community Center. That detective pulled up to my center, harassing me, attempting to bribe me in order for him to not put in the warrant. So after I turned the offer down or not paying him, you telling me he could just put the warrant out 2 hours after he came to my center and attempted to bribe me, when he had 3 weeks of the accusation to do the warrant. So if he felt that I was guilty of the warrant, he would have did it before. Then why would he wait till he come to my center the day of?
Short answer is I don't know. The long answer is you're using some loaded words like bribing and that kind of stuff.
Right, yes.
As a judge,
bribing and harassing.
Well, and I'll just say, Mr. Ramsey, as a judge, I listen to what I'm being told, and that's what I act upon. So if an officer comes in and I'm doing a warrant, first thing that I do is I swear the officer in. So no different than officers testifying on the stand. And the standard, again, at that stage is really low. It's like
Then on top of that, I provided him the security cameras video, which has my ex-girlfriend daughter sitting on my lap because I've been taking care of her. I done took care of her for 2-3 years. I provide him the security camera footage and he still takes out the warrant.
So Mr. Ramsey, as we're speaking, I think I remember your case. And I remember you have like a lot going on.
It's with my ex-girlfriend. Her daughter is not even enrolled at my community center. I avoided this lady for 5 months. She took her daughter out to my dance class and put her in cheerleading. So when she tried to re-enroll her, she just brung her without permission. She's not even enrolled. I said, if you pay the cheerleading, then you can pay me. She catches an attitude, boom. That's where all starts at. Next thing I know, she's creating accusation saying that I touched beauty in her bus.
So
when this girl lived with
Mr. Ramsey, the best thing that you can do if you don't listen to anything anybody else tells you is to get a lawyer to defend you. Okay, because you're the stuff that you're saying, I hear what you're saying, and assuming what you're saying is correct, I don't believe you have the ability to bring it into a courtroom and have it get treated the way that it probably should be treated.
The paralegal already has the video, which is why this is the only reason why I attempted to not pay the money for a lawyer, because we have video. What is the issue? We have the video.
Mr. Ramsey, you're looking at potentially spending the rest of your life in prison. And if you want to put your life in the hands of a paralegal, that's your choice and that's your decision. This is America. You have every right to do that. I would encourage you not to play with your life that way.
Of course. When will I get, because the last time you said I was gonna get bond today at the preliminary.
No, you could be eligible for getting bond today. And that's the thing. What I'll do when I get off this phone call, I'm gonna call, actually, I'm gonna see. Looks like Judge Bridgewater is doing preliminary hearings today. So I'll call Judge Bridgewater and I'll see if she can try to get you on for Wednesday. Because the felony calendars are, Mondays and Wednesdays.
Okay.
Okay. All right, sir. You're free to go back.
All right. Is there anybody that my people can contact directly for more information on this court date?
So again, the short answer to that is no. You can call the main number, magistrate court, and I think it's 770-477-3444.
Repeat that, please.
770-477-3440.
And will that be updated in the system tomorrow?
All I can promise you is that I'm as soon as we get off this phone, I'm gonna make the call and try to make it happen, but it's not my calendar.
You gave me 2 court dates. You gave me the preliminary on Monday and you gave me a bond hearing on Friday.
Right. And what normally happens, or what can happen, is the preliminary hearing date is the date to, subpoena witnesses in, all of the stuff that you're saying. You can have these people on the stand, they can be on the oath, they can be questioned. Sometimes what happens, part and parcel of the preliminary hearing date, is because the judge sits there and hears the information. Judge may reconsider bond because they've had these people testify, because it's really and truly normally the same people that testified preliminary hearing, same people that's going to testify at the bond hearing. So instead of having 2 hearings, you just have 1.
So is the bond hearing still set Friday?
It should be. And I don't know why you were brought over before me today. I mean, it just looks like it was just a mistake.
Okay.
Okay.
All right.
All right, sir.
That's gonna be everybody, Your Honor.
Thank you. Y'all gonna have to start calling me the marathon man, because I'm making these things seem like go longer and longer and longer every day. But I will endeavor to do better.
All right, Your Honor.
All right. Have a good day.